Hey there, this is Reba from Team Reba, and today I want to talk to you a little bit about agency. The state of Washington requires that all of us agents, every time you're meeting with somebody, you need to talk to them about agency. And why that matters is because it's about how does this person work with you? What are the actual state requirements from that person? And what are the obligations that they have to you as your agent? And this should be something that a person is talking about with you very easily and also comfortably, right? Because just like you would have someone come into your workplace and say, hey, what is it that you do and how do you get paid? And well, maybe they don't always ask how you get paid, but in my world, because you're paying a fee for the service, they do ask. You know, you go to your doctor and maybe ask what fee for service is if you have to pay directly. It might be the attorney. You want to find out if it's flat fee or hourly. So there's a lot of different things that are really important that you should be able to comfortably speak about with the agent that you're talking to. So anyway, just to make sure that you understand, because we send these out to all of our clients, whether you're a buyer or a seller, investment, purchaser, seller, it doesn't matter. We're required in any real estate transaction to talk to you about agency. So what it starts talking about is in the first section of it, it has a thing about what are our duties generally? What are our duties to the public? And what that means is let's say I'm at an open house or anyone in my team is at an open house. They have to act honestly and act in good faith. Meaning, if somebody comes up and asks a question about the property, then we need to answer that honestly, right? If there's something that's very obvious or something that maybe it's not so obvious, but we can point it out and it's a feature or something or benefit of the property, certainly we're going to do that. We don't have any reason to hold that information back, right? So that's the general thing, or just answering questions about the general real estate market, that kind of deal. However, then there's duties that are specific. And specifically, they get into duties of a seller's agent, a buyer's agent, and dual agency. So if we're working for a seller, then we're doing everything for that seller to market the property, get them the most exposure, help them through the process, preparations, all of that. I mean, we spend months, if not years sometimes, with a lot of our seller clients. And so it's a lot of time invested and a lot of expertise on our part that we are sharing in that case. And our job is to work on their best behalf, right? Duties of a buyer's agent is the same, right? We're working for them, making sure that we get out to properties quickly, making sure they're getting information on properties, getting the listings as quickly as possible so that they can make decisions and do whatever they need to do for their particular situation, right? But one of the things that's also very interesting about that is very similar to an attorney-client privilege. We actually do have a duty of confidentiality to those individual clients. So any information that we take in at those intake meetings and discussions is meant to be kept with that agent and that client. It doesn't get shared among everybody else. In fact, actually, even in my team, if I meet with somebody, any private information stays with me. If one of my other team members who's an agent working with a client, same thing. Like we can talk about what's going on in our weekly meeting with clients and their needs, but the confidential information stays separate, right? We don't share that information. And in the majority of cases of real estate agents, we're independent contractors. And so all of us have just our own client base, our own files, and we keep that to ourselves. Now, where things can sometimes get muddy is there's also a duty of a dual agent. And in that case, it can be a couple of different situations, right? So a dual agent can be, like, let's say in my case, it's my designated broker. So in the state of Washington, they have a designated broker who has all the legal responsibility for all the agents that hold their licenses in that office. And then there's a bunch of different agents that hang their licenses, literally, like they have to be up for people to be able to go see. They hang their licenses inside that office. Now, if I'm an agent here and one of my office mates is the listing agent and I'm working with the buyer, well, it's only RE/MAX that's a dual agent. We do not share information in between us. Our files stay separate. We're independent contractors, so we don't mingle that information. So it's just RE/MAX. Now, there are instances, our state of Washington does allow dual agency. It's not an illegal practice. In some states of the US, it is. But here it is still legal. There's been a couple times where I've actually worked with both parties in a transaction, but it's a very rare case. And since 2003, it's been very unusual. And in fact, in most of those cases, it's because I'm helping a transaction between one friend or family member to another. And they just want to make sure that they have, good services and help through the process. And maybe someone needs help with financing and doing the inspections. And we actually are limited in doing that type of thing too. We get people calling us every once in a while to just write a contract up. And we actually can't, because to only write a contract and not provide actual services that are expected of a real estate professional, that's considered acting as an attorney, and it's outside of our licensing and illegal practice for us. So just FYI, if anyone's thinking about that. But there are some people who will actually do this transaction where they do the seller and buyer part together. And that creates a dual agency. It's not only dual agent with the designated broker, but it's dual agency with the individual agent. And again, like I said, it's legal, but I personally believe the reason we don't do it between, parties who don't know each other is because now you have a conflict of interest. It's an inherent conflict of interest, because who is my duty of confidentiality really going to be with? Let's say a buyer told me what their total amount is that they would pay on a place, and the seller has also told me like the lowest price, and they kind of intersect somewhere. Who am I going to work for? Whose benefit am I trying to work on and negotiate on behalf of? That, because unless there's like really true transparency, that's a really difficult thing to have happen. So we just don't do it in our team. But it is something that's out there, and you may hear some people say that they do it. I know lots of agents who like that because they get to do what's called double ending a deal, meaning they get the commission on both sides of the transaction, and they think it's a big win. We don't like to be motivated by the money part, and that's one of the reasons we don't do it. Duration. So here's the thing. We have a buyer agency agreement, and then of course we have listing agreements. So a listing agreement has to have a deadline on it. Buyer agency agreements should have it. All good actual contract practices should have deadlines. Just like your real estate transaction is going to have a closing date, well, you should have that with your agent too. You can't just like go on in perpetuity, like that's not even possible. So you should always have those things in writing. But here's the other thing about duration. And I love having this conversation with people, because here's what I know a lot of other people don't talk about. There are 3 different ways that duration is done. So there's expiration, and we just talked about the fact that you want a contract that says how long you're planning on working together, and you have a right to re-up it if it's going beyond that period of time. And I will say most of our contracts are 6 months, because there's prep time, search time, or on market time, and then closing time, and that takes months. So if you ever have somebody, saying, "Oh, I only want 30 days," that's not realistic. It's absolutely not realistic. That you never do a transaction unless you already have everybody in place. Never happens in 30 days, right? So anyway, so there's all of that fun stuff involved in terms of expiration. But then there's completion. So let's say you do have a 6-month contract with somebody. Well, okay, you have 30 days maybe before market if you're a seller, and then you're on market for maybe a week or two in a busy market, of course. And then, let's remember the recession, there was like 18 months of inventory at one time. So, you have a couple weeks on market, you review offers, and then you have your closing period, which can be 2 weeks, 4 weeks, 6 weeks. It just depends, right? So in that period of time, yeah, you're going to have the duration, and it could finish within 4 months. So then it's done. It's called transactional agency. There's a third way that these things can also be completed, and that's by termination. So what we always like to tell our customers is that communication is absolutely number one. And so if you're talking with us, if there's something going on, if we're not doing what we said we were going to do, or someone's irritating you in some way, or there's practices happening that you're not comfortable with, and you talk to us about it, and if it doesn't change, you have every right to fire us. Now, if you're in contract on a house, your contracts also really are with our designated broker, but they're assigning. It's called a signed agency. And so they're assigning us. So if something happens, first they get the right to see if there's someone else in the office that can finish the transaction for you. But if you're just still in search mode or on market and things aren't going well, you can terminate. Just remember, everything needs to be in writing, just like your other contracts have to be. Put it in writing, email, whatever. We have you sign a listing agreement. We have you sign a buyer agency agreement. Put it in writing. And the thing is, there are times it happens. I have a famous story that I tell people. We had a seller one time who was very stressed out from medical issues and moving and retirement and other things, and just honestly just really wasn't a very nice person. And I came to my office a couple of times, and he 2 times made one of my assistants cry. Nobody wants to work with that guy. That's not a guy you want to hang out with. That's not someone you want to spend a lot of your time, effort, blood, sweat, and tears working for, because we really take pride in what we do, and we want to have good working relationships. And that means we all work together, we communicate, and we make it work, right? And if it's not working, then we can choose to part company. No harm, no foul, right? So just know that that's there. Compensation. Well, just like a listing agreement talks about what the listing fees are, which includes the commissions typically. Well, when you're talking to a buyer's agent, they should also be talking about how they get paid. And here's a big tip for you. If they're uncomfortable talking about how they get paid or what they get paid, yes, I'm pausing for dramatic, effect here. If they can't talk about how they get paid, how the heck are they going to do a good job negotiating on your behalf? So just keep that in mind, okay? Because they should be able and willing to talk about it and how it's done when it happens. And by the way, we pretty much work for free until we close a transaction. So if you take 6 months, if you take 2 years, we've had one client who took 4 years. We basically work for free with, not really for free. It's just that, we plan our business so that we have consistency. And so our business just runs along. It's no different than any other kind of company that's out there. You're constantly working with multiple people and multiple clients to keep your revenue streams going forward. And if someone's not doing a good job at doing that, they're going to be the person who's going to be pushy and difficult and trying to get you to take things that maybe aren't best for you because they got the wrong motivation. And that's also where this agency thing comes in, because it also means that we have to work for you. We're working for you. We have to put aside all the things that motivate us, including monetary, all the other stuff. I mean, we try and have personal lives, of course, but, we have to put you ahead of ourselves in this transaction. It can't be our personal motivations. It has to be us working on your behalf to what your goals are. So keep that in mind. So vicarious liability, we all carry errors and omissions insurance so that we can't financially harm anybody, even by accident. So there's something there to rely on in case there is a problem with any agent you're working with. Imputed knowledge and notice means that if somebody has lied to us and we couldn't have found that information out in some form of, the due diligence, we can't be held liable for that. If someone is just absolutely hiding information, how are we going to know? Then there's interpretation. So many people mistakenly believe that there's a fiduciary duty in this state. We actually don't have fiduciary laws of that type along agency. So instead, what it is we have 4 different kinds of laws. And they are agency, common law, tort law, and good business practices laws. And then on top of that, we have a rule book about this thick with the multiple listing service of everything we have to do. Plus, then we also have, if you're a realtor like I am, and everyone in my team is that's an agent, we also have a code of ethics and then the rules we have to follow for that. And then there's a part here about short sales, which thankfully we currently don't have a lot of those. But during the recession, there was quite a bit. So they had to add this part. And it's about making sure that a seller is notifying people if there's actually a situation, because sometimes there were agents who got a little surprised. Again, communication with your agent stops all of that. So anyway, that's pretty much it. This is all the stuff. So know that when we send you a contract for either a listing agreement or a buyer's agency agreement, this is what we're talking about. And this pamphlet, that's just page 1. We always have to have you initial it because we get audited for these files with the state. But then there's multiple, pages that actually go into more detail of what I just kind of skimmed. So thanks so much. See you later.